There was a time when children in India were working in matchstick factories, inhaling toxic fumes and barely earning rupees 10 a day. And the worst part, it was legal, or at least no one was topping it. So, what changed? The answer lies in one of India's most powerful yet often overlooked constitutional safeguards, Article 24. And the case that forced India to wake up was MC Mehta versus State of Tamil Nadu in 1996. Let's decode the legal battle that protected millions of children and why it still matters today. What is Article 24? Let's begin with the basics. Article 24 of the Indian Constitution says no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Sounds powerful, right? But for decades it was just words on paper. Children were still working in firework industries, glass factories and carpet weaving units. Why? Because until someone challenged the system, enforcement was weak and economic excuses were louder than constitutional rights. Who was MC Mehta? MC Mehta, a name every law student in India knows, a public interest lawyer. He turned courtrooms into battlefields for the environment, health and human rights. From the Ganga pollution case to the Taj Mahal preservation, his case shaped the modern India. But in 1991, he filed a PIL that shook the nation, highlighting the exploitation of children working in hazardous industries in Sivakasi, Tamil Nadu, especially in the matchmaking and fireworks sector. Thousands of children were involved, unprotected, unregulated, and unheard. Case MC Mehta versus State of Tamil Nadu and others, 1996, 6 SCC 756, wasn't just a legal challenge, it was a moral reckoning. The court investigated the working conditions of children and found them shockingly inhumane. No safety equipment, no education, and no escape. The Supreme Court didn't just give a ruling, it laid down a roadmap. Immediate ban of child labor in hazardous industries. Rehabilitation package include financial compensation, welfare fund, rupees 20,000 per child to be paid by the employer, alternative employment for parents to break the cycle of poverty. This wasn't just a judgment, it was a revolution in child rights enforcement. Why this case still matters? Now you might ask, this happened in 1996. Why does it still matter? Because child labor hasn't vanished. It has just gone underground. From domestic work to roadside stalls, from construction sites to home-based weaving, children are still being robbed of their childhood. And here's the catch, laws exist. The Child Labor Prohibition and Regulation Amendment Act of 2016 even prohibits employment of children below 14 in any occupation. But enforcement is weak and societal apathy is stronger. This case gave legal teeth to Article 24, making it more than just symbolic. It reminds us that change is possible when one voice dares to speak for the voiceless. Here's what we can all take away from this case. One person can spark a revolution. The Constitution is not just for courts, it's for every citizen to invoke. Children aren't future resources, they are present humans with rights. MC Mehta didn't win just a case, he made India introspect. He forced us to look into the eyes of a child and ask, what kind of nation are we building? And maybe, just maybe, that's the kind of advocacy we all need to pursue in our lives, legal or not. If the story moved you, if you believe every child deserves more than just a factory floor, share this video. Let's keep the conversation alive. Comment below with your thoughts on whether we are doing enough to uphold Article 24 today. And if you want more powerful legal stories, that changed India forever. Don't forget to hit the subscribe button and check out our entire landmark case playlist. The links are in the description below. The law isn't boring when you know the stories behind it. Take care. Bye.